Good afternoon, everyone, and thank you all for attending this week's legal aid session of the Lunch Bunch, where we will be discussing facing foreclosure during COVID-19. This webinar is currently being hosted on Zoom, as well as being streamed to our Facebook Live page, where you can access that Facebook page at Legal Aid Service of Collier County. It's also being recorded to be uploaded to the YouTube page. If you're watching this via Zoom, Spanish interpretation services for this webinar are available by clicking on the interpretation button in the bottom right corner and then clicking on Spanish. If you are utilizing the Spanish interpretation services, I want to note that there's an additional option to mute the original audio, which would be my speaking, so that you are only listening to the Spanish version. This webinar even after it's live streamed on Facebook, the webinar will be available on Facebook as well as YouTube for future reference, or in case you miss it and want to go back to look at it again. Before we get into today's discussion, I just want to let everyone know that the type of foreclosures being discussed today are going to be mortgage foreclosures. So this information will not necessarily apply to any association foreclosures you may be facing or have questions about. If you do have questions with an association foreclosure that you're facing, those questions can be addressed with legal aid by calling our office. The contact information for legal aid will be available at the end of this presentation. Additionally, if you have any questions during the presentation, you can type them into the Q&A box, and all questions will be addressed at the end in both English and Spanish interpretation. To begin with, I want to start with some important terms to know that you may not be familiar with, but are going to be utilized in today's presentation. A mortgagor is the borrower in the mortgage transaction. That person's typically the homeowner. So you may hear me refer to the mortgagor as just simply the borrower. So I don't want to cause any confusion there. The mortgagee is the lender in the mortgage. So that's typically the bank or the financial institution that loans the money to the borrower. And the mortgage servicer is the company that sends you your mortgage statements, handles the day-to-day tasks of managing your loan. And that's the company where you typically send your mortgage payments to. The mortgage servicer is not always the original lender that you received the loan from. This is the company that's servicing your mortgage on behalf of the original lender or the current owner of the loan. In some cases, the mortgage servicer may be the original lender, but that's not always the case. But regardless, if you had any questions regarding your mortgage, the mortgage servicer would be who you would contact with those questions. Some additional terms to know is primarily we're going to be discussing today 5 types of backed loans. So there's going to be government-backed loans. Those loans are insured or backed by the federal government. Those are going to be FHA, VA, and USDA loans. And then there are also conventional conforming loans, which are loans that are guaranteed or insured, that are not guaranteed or insured by the federal government. Those loans carry no guarantees for the lender if you fail to repay the loan, but those loans can be sold back to Fannie Mae or Freddie Mac if the lender so chooses, but not necessarily. So those are going to be Fannie Mae or Freddie Mac loans. Throughout the presentation, I'm simply going to be calling them FHA, VA, USDA, Fannie or Freddie loans. There are additional mortgage loans out there that won't be being discussed. Those are typically conventional non-conforming loans. That's not really something that a lot of those COVID protections are going to be dependent upon the lender or the servicer's policies non-conforming. So those won't be discussed. But at the end of today's presentation, reverse mortgages will be discussed. So I do want to make note of that. So if you ever have any questions regarding the type of loan you have, you can call your mortgage servicer, or you can look at the bottom of the mortgage documents you signed, so the note or the mortgage. Typically, the mortgage would make note at the bottom of what type of loan it is, but if you had any questions regarding what type of loan you have, you could always contact your mortgage servicer and they can tell you if it's government backed or if it's a Fannie or Freddie Mae. So the next thing I'm going to be discussing is different types of COVID protections that are afforded to borrowers right now due to, a lot of them were put in place with the CARES Act, but some of them were extended. The first type of protection I'm going to be discussing is going to be a loan forbearance. So a forbearance plan is an agreement that allows homeowners experiencing temporary hardships to make reduced mortgage payments or no payment at all. It's important to note that forbearances do not erase what you owe on the loan. They just pause the payments coming due for a set period of time. So in order to receive a mortgage forbearance, you need to call up your mortgage servicer and advise that you are requesting a forbearance due to financial hardships that you're facing as a result of COVID-19. At this time, servicers are providing forbearance periods of 6 months at a time without the borrower having to fill out any paperwork to obtain this forbearance. If after 6 months your financial situation has not changed, you do have the option at this time of requesting another 6-month forbearance period, which would give you up to 12 months of paused payments. Again, those payments will have to be repaid at some point once the forbearance period ends, but no late fees or penalties will accrue during the forbearance plan. So it does give you some leeway to try to save up some money until you can get back on your feet and can start to make regular payments again. Also, at this point, with the COVID protections, at the end of the forbearance period, while the missed payments will come due, they may not necessarily come due all at one time. The repayment options are going to be dependent upon the type of loan you have, so those will be discussed in further detail in a couple of slides. And I do want to make note that if you are granted a 6-month forbearance period or the additional 6-month extension, and during those 6 months or 12 months, whatever it may be for you, your financial situation changes, you can resume making your payments early. If you want to do that, so you can contact your servicer and let them know, I have additional income, I can go back to making my regular payments as well as pay back what was missed during the forbearance. So just because you're granted the 6 months doesn't mean you need to stick it out for 6 months if you want to get off the forbearance. When you've received a forbearance period, there are a couple of things that I would recommend you continuing to do. So you should still continue to monitor your monthly mortgage statements, even though you won't have to be making payments. While you're on the forbearance, you will still get these monthly mortgage statements because your loan will continue to accrue interest, but you won't be receiving late fees or any penalties for not making the payments. So if you notice any late fees on your statement while you're on the forbearance, you should call your mortgage servicer right away to get that situation worked out. You don't want to get into a situation where 6 months pass and you have 6 months of late fees that should not have been added. You should also confirm with your mortgage servicer whether or not your mortgage has an escrow account. A lot of mortgage loans do have an escrow account, but not all of them do. So you want to double check whether your mortgage loan does have an escrow account, because if it doesn't, you may be responsible for paying property taxes and insurance payments that come due. If it has an escrow account, you want to confirm whether property taxes or insurance will continue to be paid through the escrow. But if it does not, then you do need to be aware that any property taxes or insurance payments that come due during the forbearance period will still need to be paid by you. I also want to mention that it may be a good idea that while you're on a forbearance period, if you do start to get some excess income, after you've paid all of your living expenses, you notice you have a little extra, it may be a good idea to put that extra income into a separate account or a savings account so that you have it on the side stored so that when you're ready to end the forbearance period, you have some money to try to pay that down a little quicker. Because while you do not have to make a lump sum payment at the end, if you have that stored away, you may want to make that lump sum payment just to ease the financial burden. The previously discussed forbearance protections originated mainly through the CARES Act. While mortgage forbearances are not a new feature of the industry, the CARES Act did allow for longer periods and for no additional paperwork. So that's where the 6 months and then the 6 month additional period came in, along with not having to fill out any paperwork with your servicer. So under the CARES Act, if you had a mortgage backed by the federal government, so a VA, FHA, or USDA mortgage, or if you had a Fannie or Freddie mortgage, you could pause your payments for 6 months without filling out any paperwork with your servicer. Even though the CARES Act protections have expired, many of these protections have been extended by the VA, FHA, USDA, Fannie, and Freddie. So if your financial situation has only just changed and you're just facing that loss of income, you may still have the 6 month forbearance period as an option to you to enter into now. So you would want to contact your mortgage servicer right away to try to get your mortgage on a mortgage forbearance plan so that it's not showing up as delinquent. If you were current on your mortgage before this loss of income, and you're on the forbearance plan, it should still be reported as either a forbearance or current. But I do want to make note that if it was delinquent before the forbearance period and then you go on the forbearance plan, it may just continue to be reported as delinquent. So once your forbearance period ends, whether it was a CARES Act forbearance or just the extension of the CARES Act forbearance plans that the servicers have put in place, there are a couple of different options. So like I said, at this time, the servicers are not requiring one lump sum payment of the amount while the loan was in COVID forbearance. But if you are able to make this lump sum payment, you do have that option. The mortgage servicers will allow you to pay it all in one lump sum, and then your mortgage will just be considered reinstated and you'll just continue paying your regular monthly payments. If a lump sum payment is not an option for your financial situation, you do have other options that you can discuss with the servicer. So including a repayment plan where you make a set amount of an additional payment on top of your regular monthly payment. You may be able to lengthen the term of your loan to pay off the missed amount with additional mortgage payments at the end of the current term. Another option you may have is the option to defer your missed payments so that that missed amount gets paid off if the home is sold, if the mortgage is refinanced, or if once the mortgage term currently ends, then you may just be able to defer that payment till the end so that you can save up until then. The last option that may be available to you is to apply for a loan modification program. That program would change the existing terms of your loan. So it could change the payments, it could change a couple of different things, but those options can be discussed in detail with the servicer to figure out what the best option is for your current financial situation. Because you will, once the forbearance plan ends, you're going to owe that missed amount on top of the regular monthly payments that are going to start coming due now. So you should know that Once the forbearance plan is over and those regular monthly payments start to come due, if you miss a regularly scheduled payment, then you will now start to get, again, the penalties, late fees, and all of that. So if when the forbearance plan ends and you still can't make these payments, you do also have an option to try to reach out to your mortgage servicer to discuss additional loss mitigation options. Additional loss mitigation options might require you, though, at this point now to fill out additional paperwork. That paperwork can include sending financials, W-2s, W-9s, that sort of thing. But it may give you some other options of how to rectify your financial situation and owing these monthly payments on top of the deferred amount. I do want to note, though, a lot of these things are dependent upon you calling your servicer, and COVID has financially impacted many homeowners and borrowers at this point. So call volumes may have increased. You may have greater wait times when calling to speak, so you should take note of that. Some of these servicers offer online portals where you can log into. These portals may have been where you were paying your statements to begin with. You may be able to manage some of your mortgage activities through these portals, so you can log on and see what's available before you just start to call. So there are additional COVID protections being offered besides the forbearance plans. The next major one is foreclosure moratoriums. With the CARES Act, there was just a moratorium across the board, and then there were also state level moratoriums. But as of October 1st, 2020, in the state of Florida, there are no specific state foreclosure moratoriums in place. So each mortgage moratorium I'm going to be discussing is dependent on the type of loan that you currently have. So to begin with, we're going to start with FHA loans. In a press release dated August 27th of 2020, the Federal Housing Administration announced the third extension of its foreclosure and eviction moratorium, and that is set to expire December 31st of 2020. This extended moratorium by the FHA directs the mortgage servicers that are servicing FHA loans to halt any new foreclosure actions and to suspend any foreclosure actions that were previously filed on an FHA insured single family mortgage. Vacant properties and abandoned properties don't apply. So this moratorium does not apply to any properties that the servicer already had marked and recorded as being vacant or abandoned. So if you are a borrower on an FHA insured loan that is secured by a vacant or abandoned property, that foreclosure can still go through, even though there's a moratorium. So the next type of loan is a VA loan. So again, after the CARES Act expired, the Department of Veterans Affairs decided to extend the foreclosure moratorium on VA guaranteed loans until December 31st of 2020. This moratorium applies to the initiation of foreclosure actions and the completion of current foreclosure actions. USDA loans. The USDA issued guidance again extending the foreclosure moratorium until December 31st of 2020, but this mortgage moratorium does not apply to any vacant or abandoned properties. But again, the servicers for both VA and USDA loans have been directed to suspend any initiation of foreclosure actions or the completion of any currently filed foreclosure actions. Fannie Mae and Freddie Mac have both also decided to extend the moratorium on single family mortgages as well. This moratorium was also extended until December 31st of 2020. So all of the moratoriums I just discussed have all been extended until December 31st of 2020 at this point. That's at that time, things may change, but at this point, the moratorium is only until December 31st of 2020. So again, Fannie and Freddie's moratorium protections do not apply to tenants in homes that have been foreclosed, and they also are not going to apply to any vacant or abandoned properties. But if it is a residential property that it's a single family home or mortgage, again, the foreclosure actions, the initiation will be suspended. Any existing foreclosure actions, those will be suspended as well until this moratorium is lifted. So all of these protections are really dependent upon who your mortgage is backed by or insured by. So like I had mentioned in the beginning, in order to find that out, if you're not aware, is the first thing you can do is just contact your mortgage servicer. Once you contact the servicer, you can ask them and find out whether you have a government or a conventional loan and who's backing it, whether you have a VA, an FHA, a USDA, a Freddie, or a Fannie mortgage, and which of these protections apply to you. Again, the contact information for your mortgage servicer will be found on your mortgage statements, or if you have a portal, it'll be found in your portal. If your mortgage is not one of the previously discussed types, and you still want to know what options are available to you, there may still be options that the lenders and the servicers are putting into place. You would just need to call them to find out specifically through your mortgage servicer and to discuss what options. They may still include forbearance plans, but you're going to want to know at that point how those payments are going to be expected to be repaid, whether it's going to all be due in one lump sum or if they're going to be repayment plans. I did include some websites to note, since your mortgage servicer is really the critical party that you have to answer as many questions as possible, and you're unable to locate any statements, you don't have a portal, you just don't remember who your servicer is, you can still locate that information by going online to the Mortgage Electronic Registration Systems website. When you go to that website, they are going to ask you a couple of questions regarding the property address and some of the borrower details in order to look up who your servicer is. The next two websites listed you can use to determine whether you have a Fannie Mae or a Freddie Mac loan. Again, if you want to reference back to these websites later on, this is going to be recorded, so you can find this webinar on our Facebook page or on our YouTube page. So at this time, I'm going to be turning over the presentation to Attorney Kathy Lucrezi.
Hello, everyone. As Megan said, I'm Kathy Lucrezi. I'm one of the attorneys at Legal Aid Service of Collier County. And I wanted to talk about reverse mortgages because I think for many seniors, they're a thing that sounds really good, but they can be confusing. So what is a reverse mortgage? Megan has just gone over all of the different things dealing with mortgages. All that reverse is where you get a loan against the equity in your house. You keep the title to your house. You are still the owner of the house, but you're drawing money out of the equity that you have in the house. And usually this money is paid out to you in a single payment, usually used to pay off any existing mortgages, or it's paid out monthly to keep up the mortgage payments. In other words, if you get a reverse mortgage, the most common thing that people do with it is to avoid having to make the regular monthly mortgage payments. So if you've got a house, every month you send off a mortgage payment to the servicer, but you can't do that anymore because the funds are so little. If you qualify for a reverse mortgage, the lender will take over that. You will not have to pay the monthly mortgage payments to the servicer. That's the way most of these go. But there's also other ways that the money can be paid out. In some reverse mortgages, the homeowner decides to take a line of credit. And it's like having a pool of money available to you that you can pull cash out for whatever needs you might have. There's a term option, which means that the loan would pay you on a monthly basis some amount that's determined by the math of what can be paid out over a period of time. A 10-year option is very similar, except it will go for the length of the time that you are living in the house. Like I say, those last three, they're not done very commonly. Usually it's the first one. People get a reverse mortgage so they can quit paying monthly mortgage payments. So how do you qualify? Reverse mortgages are not for everybody. You have to be at least 62 years of age. You have to own the property, or you've paid most of it down on the existing mortgage. Otherwise, you don't have equity. Remember, this is a loan against the equity in your house. So you have to own the property or have paid down quite a bit of it. You have to live in the property as your principal residence. You can have a vacation rental on the south of France, but as long as this house is your principal residence, then you can qualify for a reverse mortgage. Now, this next one is really critical. If you get a reverse mortgage, you must be able to continue paying property taxes, insurance, association fees. In other words, that reverse mortgage might get you free of the monthly mortgage payments you were making before, but you still have the obligation to pay property taxes and insurance and association fees as they become due. So when you apply for a reverse mortgage, they will ask you for financial information to be sure you can afford to do these things. To qualify for a reverse mortgage, you have to meet with a consumer information officer. It's a HUD-approved counselor. This is free counseling, and it's to make sure that you understand what's involved in a reverse mortgage and what your obligations are. You cannot be delinquent on any federal debt. So if you owe the federal government money for a tax lien or some other debt to, that the United States wants to collect, you're not going to get a reverse mortgage. I want to start off with about some cautions about reverse mortgage. I think everyone has seen commercials advertising reverse mortgages, and they're very nice, and they sound wonderful, but beware, because there's also some bad ones out there. Look out for these signs. If the person you're talking to is trying to sell you the reverse mortgage because it will solve all your problems, walk away. If the agent has great ideas on what you can do with the money you get, walk away. If the agent tries to sell you something else, like get this reverse mortgage and we will install new windows or an air conditioner to your place, walk away. If you're being rushed through the process, walk away. Because the good, reputable people who are selling reverse mortgages will not do those things. They will want to be sure that you know what you're getting yourself into. So protect yourself from fraud. If you don't understand the papers you're signing, walk away. If you feel pressure to complete the transaction, walk away. And always do some research. Find out if this person you're talking to is legit. Have there been complaints about the person, or complaints with the Better Business Bureau, or has the HUD-approved housing counselor heard of these people, what do they think of them? Protect yourself. Now, the person or the bank, let's say the lender, who is making this loan to you will collect their money in one of these three ways. They will collect the money upon the death of the borrower. In other words, at the time of your death, the lender will collect what they're owed from the equity in your house. Now, what that means really is that it might deplete or lessen what you can leave to your heirs. So if you get a reverse mortgage and you're thinking, I'm going to leave the house to my son, know that the reverse mortgage is going to get paid off first. And whatever's left could go to your son, but the reverse mortgage is going to come first. The lender will also collect if you sell the home. So there's nothing that says you're forced to live in the place until the end of time. If you want to sell it, terrific, but just know that you're going to be paying off that reverse mortgage. The third way that the reverse mortgage ends is if you're no longer using the house as your primary residence. So if you decide to move to some other place, then you'll get a letter from the lender saying, hey, are you still living here? What's your primary residence? And if it's not the place that is part of the reverse mortgage, they're going to say they want to collect what they're owed. What often happens for seniors, and remember, this is always limited to people who are 62 and older, if the borrower goes into a nursing facility and is there for some period of time, they can still say the house is their primary residence. If they're in the facility for more than a year, then it may not be considered the primary residence. So if you have a reverse mortgage and you're in a situation where you've gone into the hospital or nursing home or jail for that matter, you want to get some legal advice about what you can do to protect your house from collection on the reverse mortgage. The reverse mortgage will not cover your property taxes, your homeowner's insurance, the association fees, or the cost to maintain your house. If you fail to make those payments or fail to do those things, they will foreclose. And I have to say that here at Legal Aid, when we most often see reverse mortgages in foreclosure because the homeowner has failed to pay the property taxes and insurance. Maybe that's because when you're under a regular mortgage, you're used to making one payment per month to the servicer, and then the servicer pays the taxes and insurance on your behalf. Not so with reverse mortgage. And so if you're on a reverse mortgage, then you have to pay those things. And if you don't, you're going to face a foreclosure. You have to keep up the house. If you allow the house to become damaged or just deteriorate, the lender can say you're not protecting the property and they can start a foreclosure. Now, in Florida, of course, we all face damages that come from hurricanes and severe weather. Usually the lender is very tolerant and they will wait for you to get repairs done. But you need to make sure that you get the repairs done. I want to thank everybody for attending. I really hope that there's questions that you'll propose to us. If you want advice on your particular situation, whether it's about reverse mortgages or about the mortgage programs and the forbearance that Megan spoke about, please contact our office. We represent low-income individuals and individuals in vulnerable populations of all sorts, and we are happy to talk with you about your situation. Feel free to contact us. You've got the numbers there, and as Megan said, this presentation is going to be on the webpage. You can find us there. I want to do a special thank you to the sponsors that help us exist. And without their support, we would not be able to offer this kind of service or any of the other services that we do. We're a nonprofit law firm. We have a large staff of attorneys and paralegals. We cover more than housing. We cover lots of different areas of law, including representing children, domestic violence victims. We handle tax cases, just about everythh. So please call us, and we're happy to see if we can help you out. I'm gonna get out of the share mode here to see if we have any questions. You can type your question in the chat box, and we'll see what we can address. While we're waiting, Megan, perhaps you could just describe what the typical path of litigation there is for a foreclosure case.
Yes. So typically in Florida, Florida is a judicial foreclosure state. Not all states are, but what that means is in order to foreclose on your property, the lender or the servicer needs to start a foreclosure lawsuit, and everything has to be done through the courts. So the first step in that foreclosure process is once your account is delinquent for a certain amount of time, typically 90 to 120 days, your mortgage servicer will send you what's called, you'll either see it referred to as a breach letter or a default letter. A lot of the servicers use the terms interchangeably, so you may see it called either one. I'm going to refer to it as a breach letter, but if it includes the same information and it's titled a default letter, it's probably what I'm talking about. So this breach letter will be sent to the property address, typically. If you don't reside at the property address, it'll typically be sent to the property address and also whatever address you have on file with your servicer. This letter will inform you as the borrower that the loan is in default. It's going to include information regarding the default, so which payments have been missed, the actions required to cure that default, so that is typically the amount that's going to be required for you to pay to bring the loan current. It's going to include a date by which that default must be cured by. That's the date's typically within 30 days. And also a notice that a failure to cure the default may result in acceleration of the entire loan. So that would bring the entire loan due and owing. So if you took out a loan on your property for $300,000, it's going to, and you've only paid 50 of that off, so you still owe a decent amount on that when you include interest and any late fees or penalties. It's going to bring that entire amount due and owing if you don't cure the default. If the default is cured within that 30-day time frame, then always confirm with the mortgage servicer that the loan is now showing as current. If it's showing as current, then you're fine. But if the default is not cured within that time frame, the next step is for the lender or the servicer to hire an attorney to start the foreclosure process. So the next step would be to file the complaint. After the complaint is filed, you're now going to be served with both a copy of the complaint and a summons. All of the defendants in the action that are named are going to be served. So if there are any junior mortgages on the property, junior lien holders, they'll be served as defendants. There's going to be named and unnamed defendants typically. So there'll be any tenants could be named potentially, or they could just be referred to as unknown tenants. If it's not known whether you have a spouse, it'll be the unknown spouse could be named. So all of those defendants, named and unnamed, will be served with the complaint and the summons. After you receive the summons and complaint, all of the defendants have 20 days to respond. You can respond at that point. Once you get that, you can either decide to reach out to an attorney, or you can decide to represent yourself and file all of your answers pro se. But you do have 20 days to respond after receiving that complaint. That response could be an answer, or it could be a motion to dismiss. There are a couple of different options you have. Those, again, could be either discussed with an attorney, or if you choose to represent yourself, you could look that up and research that process of how you're going to want to respond. If any of the defendants don't respond, the next step would be for the plaintiff to bring what's called a motion for default. At that point, that just means that whatever defendants are being brought named in that motion for default, those defendants did not respond. So they have not appeared in the action, and it's a way to get for the plaintiff to then get a default final judgment. If you as the borrower or any of the defendants do respond, then typically either the plaintiff's attorney could bring a motion for summary judgment or set the matter for a non-jury trial. And this is, again, just a streamlined process of a streamlined foreclosure action. Again, there's always different things that could come up, but this is going to be your typical process. So if the plaintiff brings a motion for summary final judgment at that hearing, and the defendants should all get notice of any hearings that are scheduled, along with being served with all of this paperwork. But again, if they bring a motion for summary final judgment, at that point, the plaintiff is going to argue that there's no material issues standing in the way, that everything they've alleged in their complaint is true and accurate, and that they are entitled to that final judgment. If the borrower or any of the named or unnamed defendants did file an answer raising a bunch of defenses, then the plaintiff will most likely just set the case down for a non-jury trial. A non-jury trial means there is no jury. The judge is going to be acting as the decision maker. So at the non-jury trial, that's when both sides are going to be able to present their cases. So any witnesses you have, any documents you want to introduce, any arguments or defenses you may have raised and want to have heard by the judge, that's going to be your time to do it. In a trial, the plaintiff will go first. They'll present all of their witnesses and documents. So the documents typically presented will be the note, the mortgage, the default letter, among other documents, depending on the type of case it is. But those are going to be the standard ones, again, in the standard hypothetical foreclosure action I'm discussing. But then once the plaintiff presents all of their evidence, you as the defendant will then get a chance to put on your case. So if you have any witnesses, if you have any documents you want to bring, arguments to raise regarding the defenses you've already pled in your answer, this is your time to do it. At that point, once both sides finish, both sides have rested, the judge will review all of the evidence introduced, all of the documents, all of the witness testimony, and will either issue a ruling right away or could decide to review the information and issue a ruling at a later point. If a final judgment is entered at that point for the plaintiff, then there's going to be that final judgment amount, which will be all costs, late fees, everything owed on that amount, on that loan. And the judgment will also set a sale date. Typically, a lot of times the plaintiff will just want the soonest sale date. Depending on the judge, that's soonest is typically anywhere from 20 to 45 days. 30 being standard, but it could be that 20 to 45 day period. The plaintiff may be willing to enter into an extended sale date, but that would be something that the defendant and the plaintiff could discuss. Once that sale date is set, on whatever day the sale is set for, the property will be auctioned off and sold to the highest bidder. So that is going to be your typical standard foreclosure action.
Thank you, Megan. We're about to close, and I just want to say next week's Lunch Bunch webinar is on commercial leases, and it will be perfect for anyone who is starting up a business, thinking of starting up a business, or who's just started a business. Tell them to tune in. The commercial lease will talk about how that business deals with renting space for it to conduct business. On behalf of Legal Aid Service of Collier County, my colleague Megan Sullivan, and our translator Vanessa Acevedo, thank you very much and have a wonderful day. Goodbye.